So you lied to them.
Yes, sir.
So is it your practice to lie to a suspect? She saw an outline of a gun. Is there any evidence you collected showing that my client pointed a gun at Ms. Long?
No.
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss.
This began as a road rage case where the defendant allegedly brandished a weapon on the highway at 0:30 in the morning. But once the defense started asking questions, the trooper admitted something critical. His case was weak, so he lied to the suspect. His case is weak. Even Judge Oakley said,
I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role.
so what really happened here? Let's roll, nerds.
To April 23 of this year at about 6 in the morning. Do you recall your whereabouts?
I was on my way to work on 675, coming up to my exit, to get work.
What type of vehicle were you driving?
I drive like a tannish gray Chevy Trailblazer.
Are you alone in the vehicle or do you have company?
No, I was like, so.
You started telling the judge about you on 275 North. Anything unusual happened to you when you were traveling on I-275 North?
I was on my way to work that morning and I noticed that there was a vehicle behind me. The vehicle was very close to the, rear of my car. I had changed lanes a few different times. If I'm not mistaken, I changed lanes a total of 4 times.
Tell us about the weather. Was it light out or dark?
It was typical, nighttime, right before the sun's coming up.
Anything more unusual happened while you were traveling on I-275 North?
When I noticed that vehicle behind me, and like I said before, I had changed lanes. The vehicle followed me. I want to say it was the 3rd time that I had changed lanes. The vehicle followed me again. I did brake check the vehicle behind me, which I know you're not supposed to do.
What happened after you brake checked?
You got to get closer. And so I had moved back into the middle lane, and he was again right behind me, even closer to the floor.
Anything happened after you changed into the middle lane?
Other than him following me, no, not until I had gotten up to closer to the exit I was getting off at.
Which exit is that?
The West Huron exit.
Anything unusual happened there near that exit?
Yeah, as after I had been followed back into the middle lane, I was just nervous at this point. So I waited until the last possible second, made sure that the lane next to me was clear, and I just booked it right off of the exit. And then that's when the vehicle pulled up next to me.
Anything happened when that vehicle pulled next to you?
I saw the outline of a handgun pointed at me.
How far were you from the person holding the
The
handgun?
vehicle had moved right next to me in that lane, so.
Can you give us an estimate on the distance? I'm going to walk towards you with the judge's permission, and you stop me when I reach that distance.
Probably about right there.
Judge, may the record reflect about, I know I'm short, but about 7 feet.
Mr. Weinberg, thank you.
How certain or uncertain are you that a gun was pointed?
100% positive, I saw the outline of the handgun.
Sir, can you identify that man at the table? You cannot identify my client, Mr. Jeremy Taylor, is that correct?
Objection's been asked to me. It's
Is that correct? You can't.
been an objection asked.
Clarification.
So you have no idea whether or not Mr. Taylor was the man you're talking about that day, correct?
No.
Correct. And it was too dark to identify him. Is that correct? What time of day was it?
5:30 roughly in the morning.
5:30 in the morning, so it was dark. And when you claim that he actually pulled up next to you, was the light in his vehicle on?
No, the lights on the, other side of the freeway, that's how I could see that that's a behind, but I could not see
Okay.
his face.
Okay. So you didn't see a gun, you saw the outline of the gun, correct?
Right.
You can't identify the gun, correct? Can't identify the model or make, correct? You saw an outline of what you thought was gun, correct?
Of what was gun, yes.
Well, did you ever touch that gun?
No.
And you can't identify anything other than the outline, correct? Right. Have you ever seen a gun close up before?
Yes.
Have you ever seen the outline of a handgun like this gun before?
To me, handguns for the most part look my thing.
Did you understand the question?
Yes.
My question was, did you ever see an outline of that specific gun before?
I can't answer that.
You testified that this was a road rage type of situation, correct?
Yes.
At some point, you slammed your brakes on in front of him while you were driving, isn't that correct?
Correct.
And that would precipitated this incident, correct?
We object. She doesn't know what you said.
No, well, here,
Excuse me. We don't know what's in the mind of the other person.
that's fine, but
So that was a speculation objection
Yeah.
response?
I believe that maybe Mr. Gallo doesn't understand. Yeah, I believe the witness understands. Did you understand my question?
Yeah, we object. I didn't say that. We started to understand.
You're asking her, let's rephrase that.
So I'll rephrase.
Was that the first incident between you and the other vehicles when you brake checked the vehicle?
Did you at any point advise Mr. Taylor or Ms. Brandon?
I did, yes.
How did that?
Traffic stop was conducted and I pulled him over on 275 near Eureka. Spoke to him briefly, introduced myself, asked him if there were, or he declared to me rather, I didn't have to ask, he declared to me that there was a firearm in the vehicle, that he was a CPL holder. Shortly thereafter, I read him his Miranda rights, took him into custody.
So don't go any further.
Yes, sir.
Terms the Miranda.
Yes,
When reprising of such rights, did you do so from your memory or from a form?
that's read to him from the form. I read it to him.
Can you estimate for Judge Oakley the number of times you've read Miranda rights to suspects?
Fair estimate would be several hundred times.
In doing so, in this case, did you read some of the rights, all the rights, or none of the rights to you listen?
Oh,
How long did you speak to Mr. Taylor?
I would say, I would, an estimate approximately an hour.
Now, after reading him his rights, did you ask whether he wished to speak to a lawyer?
I'm sorry, what's
Did you ask whether he wanted a lawyer or whether he wished to remain silent?
Yes,
What was his response?
he agreed to talk, he said we would his rights to talk.
Did you offer him any promises of leniency to speak to you?
No, sir.
Did you threaten him in any way?
No, sir.
Did he appear to be deprived of food, water, shelter, sustenance, or sleep?
No, sir.
Then he's up spoke.
That's right.
But what if any, did you inquire as to where his whereabouts earlier in the day, like April 23, 2025, at about 6 in the morning?
Yes, I did.
What did he tell you his whereabouts?
He explained that he was traveling on northbound 275 on his way to work at approximately that time.
Did he indicate where he was headed, where he was coming from?
He was coming from his home and headed to his workplace in Van Buren Township.
Did you inquire about any incident that might have occurred between the vehicles?
I did.
What's the specific question you asked him?
I asked if there was any unusual road rage type incidents that had occurred that.
What did Mr. Taylor say in response?
Initially, he denied that there was, saying that something had happened the day prior.
You said initially he did it.
That's right.
What does that mean?
So when I first asked that question, had anything unusual like a road rage incident happened, he said, no, not this morning. Yesterday, something happened between me and a female in a light colored vehicle.
Does he give a different answer at some point?
He does, yeah.
How is the transition occur?
So I asked further questions about that incident. And I said, well, there was an allegation that something happened this morning. And then he said something along the line of, oh, maybe that was this morning. And then goes on to describe the victim's vehicle and somewhat of a road rage interaction between them.
Did he indicate to you any specific actions he claimed that the other woman took?
To my memory, that she brake checked them and flipped them off,
What is slipping off?
presenting her middle finger to him, a derogatory manner.
Did you specifically ask him whether he pointed a gun at another moment?
I did, yes.
What did he say?
He denied this.
Does he later give an explanation?
He does.
What does he say?
He said that it could have been that what she saw was him pointing his finger at her, and then later added that he may have had a coffee mug in his hand at the time he pointed this.
Isn't it true that you took him out of his vehicle and had him sit in your swagger, correct?
I don't recall at what time in the time or when in the time frame he sat in my vehicle, but he did sit in my vehicle. That's right.
And had when he was in your vehicle. Is that when you read his Miranda rights or is it after?
I don't recall.
But you recall getting a statement from him after you read his rights?
That's yes,
It was clear.
yes.
And do you recall your conversation when you spoke?
I do.
Do you recall the questions and the and the comments you made to him when you were interviewing?
Not every comment, no, I'm sure not.
But you remember your conversation.
Yes.
And do you recall telling him the rendition of what was her name, the complainant?
Miss Laurel.
Ms. Moore, what she had told you or what your understanding is what the complaint was?
Yeah.
And that there was some type of pointing the gun at her, correct?
Right. Yes.
Isn't it true that you told him that that he was involved in an accident with this woman? Do you recall that?
I don't recall.
Do you recall telling him that there was evidence to show that he actually did point the gun at her
Yes.
from a video camera?
That's right.
Do you have any evidence of it?
No, sir.
So you lied to him about it.
Yes, sir.
And is it your practice to lie?
Judge, he's allowed to lie.
Well, I'm asking,
He can be Pinocchio, it doesn't matter. Say whatever he wants.
I understand that and I agree with you, but that doesn't mean Mr. Weinberg can't ask me questions about it.
so is it your practice to lie to a suspect during the investigation?
We object to that question. It doesn't matter what his practice is. It could have been the first time he lied, or he lies all the time. It's not relevant.
That would be irrelevant. Go ahead. Relevance objection.
It's not only relevant, rather, it's also goes to his experience and his practice as a trooper. The prosecutor went into excruciating detail about how many types of stops he had, and whether or not he's had gun types of investigations, whether or not he loaded, how he knows is it practical to have something on his hip if it's holstered or not. You're just going by his practice in terms of interviewing witnesses.
You're stretching, but I'll allow it.
So is it your practice to lie to a suspect while you're doing an investigation?
But it's not necessarily my practice, no, sir.
But you chose to do that in this.
Yes.
Besides Ms. Laurel saying she saw an outline of a gun, is there any evidence you collected showing that my client pointed a gun at Ms. Laurel?
No, sir. He said that he may have pointed his finger and did something like this.
So for the record, can we agree that the trooper has stood up and pointed his index finger with his thumb closed?
Running have an interesting case before you, and we have a very good defense lawyer. Judge, in this case, the witness says a gun was pointed at her. Could she be mistaken? Yes, she could be mistaken. The question is the probable cause that the gun was pointed at. She seems certain, Judge. Despite a very effective cross-examination by Mr. Weinberg, she said that was a gun. I saw the outline of the gun. I've seen guns. That was a description. Now, in terms of who the culprit is, whoever did this, Judge, allegedly did it. He's driving a dark-colored Chevrolet Malibu with the first three digits of the license plate being EJ5. Now think about that, Your Honor. Think of the coincidence if he's not the one guy. It means somebody else driving a dark-colored Chevrolet Malibu in that area on I-275 North was involved in this. A license plate links him. Can I say to you, and can you consider this family, you're 100% sure? No, but think of the likelihood of this license plate featuring EJY and it being a dark-colored Chevrolet Malibu. And you had a gun in the car. And it wasn't holstered. Now that's important. It means it's readily accessible. This was a low-grade incident that spiraled out of control, and it's very unfortunate, but fortunately, nobody was injured. And the finger, once he thinks he's been nailed, oh yeah, they might have some video, they might have something where I'm pointing the gun, so, maybe it was my finger. That's not something you forget, Judge. It wasn't as though he had been interviewed weeks later. Yeah, maybe I pointed a finger. We would ask around to find the case, so where's Judge?
Mr. Weinberg.
Thank you, Judge. Well, I will go by a much better prosecutor than I may be as a defense attorney, but it can't just be, he could be mistaken. This man is charged with a 4-year felony and a mandatory 2-year felony firearm. They better have more than simply, she could be mistaken. She did not identify a gun. They have no pictures of a gun. They never identified any gun that she identified. They never had any evidence saying, yes, that's the gun that was used, or this is what the gun looked like. It was an outline of a gun where she readily admitted it was too dark even to identify my client. It was at 5-something in the morning. There's no lights other than maybe some street lights. She has an extremely weak testimony in this matter. But for the grace of God, go us in this kind of case. If someone can just drive up and say that they actually saw someone with a gun, then they get them charged with this. So I disagree with this experienced prosecutor who's handled thousands of these cases that there is enough evidence to bind my client over. Maybe if they had the gun. Maybe if they had, or even identify my client as the driver of the car, but they don't even have that. So I'm asking the court to dismiss this.
Go ahead.
And reviewing, you know, the start of night, but in reviewing the case, you're determining whether there's probable cause to need the private verdict. Then there's more than probable cause here. Thank you.
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role. I'm going to bind it over.
Thank you. Thank you.
AOI is October 29.
October 29, 9 a.m. Bond will continue. Good luck downtown, gentlemen.
Thank you.